Great. I'm going to go ahead and get started. Thank you all so much for being here. I'm Congresswoman Stephanie Murphy, and I represent Florida's 7th Congressional District and serve on the Ways and Means Trade Subcommittee. I apologize for the delay, but I'm coming just straight from the USMCA press conference. And we're competing a little bit with that right now, but it is with a lot of gratitude that we are able to make the announcement that I think a deal is done. I think that's really good news for trade and for the American people and the American workers. So that's ongoing right now, and I'm excited that we finally got to this point nobody ever thought would happen, but we're here. Anyways, we're here today for the second in a series of briefings that I recently began hosting on international trade issues that affect America's economy and America's security. The goal really is to have a panel of experts explain in clear and concise terms why a particular trade issue matters or should matter to everyday Americans. And last month, we held our first inaugural briefing on the U.S.-China trade conflict. The panel agreed that while China was violating the letter and the spirit of the commitments it made when it joined the World Trade Organization in 2001, at the same time, though, they expressed the view that the administration's tariff-focused, go-it-alone, without allies approach was unlikely to compel China to change its problematic conduct. The panelists also highlighted the economic pain that U.S. tariffs and Chinese counter-tariffs are causing here at home, and the additional pain that could be felt if the U.S. imposes the next round of scheduled tariffs later this month. And finally, we discussed alternative policy approaches that would maximize the pressure on the Chinese government while minimizing the pain on American businesses and American consumers in the process. Today, the subject of our briefing is the WTO itself, with a focus on the causes and consequences of the crisis at the organization's appellate body. This might seem like an academic or abstract topic, but it's incredibly important as a practical matter, and I don't think it's getting enough attention here in Congress or in the media. I hope that today we can distill down to its essence and underscore what's at stake for the American workers, American businesses, and American consumers. To say this briefing is timely is quite the understatement. The crisis at the WTO is no longer impending. It's now officially upon us. The crisis involves a dispute settlement system, which has been called the crown jewel of the WTO. When one of the WTO's 164 member countries believes that another member country has violated the rules of the global trading system, it can turn to the WTO to resolve its claim. And typically what happens is a 3-person panel will hear the case and render an initial decision. The losing party can appeal that decision to the appellate body, which they usually do. And the case is not considered final and enforceable until the appellate body acts. And we have heard a lot about the importance of enforcement when it comes to trade deals. So this body is critical in that element of enforcement. The appellate body is supposed to consist of 7 judges, but at the start of the Trump administration, the appellate body had the full slate of 7 members. And in 2017 and 2018, the terms of 3 judges expired and 1 judge resigned, leaving the appellate body with just 3 judges, the bare minimum needed to hear an appeal. However, today, the terms of the 2 remaining judges expire. And so there will only be 1 judge left, which means that there's no longer a quorum and no functioning appellate body. And this is happening because the Trump administration has been blocking the appointment of any new judges to the appellate body, to the dismay of many of the other member countries. It's doing so based on a number of substantive and procedural concerns about how the appellate body operates. And as we'll hear from our panelists today, the Trump administration's main concern is that the appellate body has been engaging in judicial activism, making the law rather than just enforcing the law. And behind this general concern with judicial overreach is a more specific concern. The U.S. wins over 85% of the cases in which it is the complainant. So claims by the president and others that the U.S. never wins at the WTO are actually inaccurate. The U.S. does lose about 75% of the WTO cases in which it's the respondent, and that's actually relatively good compared to other countries. Still, those losses have upset the U.S. government and some U.S. industry stakeholders. The losing cases tend to involve U.S. trade remedies, This is when the U.S. imposes tariffs on another country based on a finding by the U.S. government that the other country is engaging in unfair trade practices, like dumping its products into the U.S. market at artificially low prices and undercutting competition. On a number of occasions, the appellate body has ruled that the U.S. has overstepped its authority in imposing these trade remedies. It's these cases that seem to be at the heart of the Trump administration's concern with the appellate body. And to be clear, the Obama administration and the George W. Bush administrations also had these concerns. And so today we'll ask and answer three main questions. First, are the U.S. concerns with the appellate body legitimate, illegitimate, or some mix of both? Second, what's the best path forward to break the current impasse? Are there institutional reforms or workarounds that would lead the U.S. to agree to appoint new judges? Two of our panelists, Jennifer and Jeff, have written extensively on this issue and have put forward numerous creative proposals. Third, and finally, what are the practical consequences for American interests if no agreement is reached and the appellate body really does cease to function? In my view, this last question is the most important one. Just as I'm concerned about the wisdom and effectiveness of the administration's approach to China's abusive trade practices, I'm concerned about the administration's approach to the WTO. There's an old adage that says you don't know what you have until it's gone. And I think that really applies here. And while we may lose some cases at the WTO, and we aren't happy about that, and we may be right that some reforms are required, is really destroying the WTO appellate body the right answer? Doing so, I think, could be a disaster for U.S. interests and for the rules-based global trading system that we've spent decades building. We would essentially be back to the wild, wild west as it relates to global trading. And the absence of a binding, independent dispute settlement system could turn every trade dispute between nations into a mini trade war with countries unilaterally imposing tariffs and counter-tariffs on each other. That would mean new and damaging taxes on American companies and consumers, because let's be very clear, tariffs are taxes on the American businesses and American consumers. And this will all occur without Congress, which has the taxing power. And it'll occur without Congress having passed a single law or otherwise blessed the administration's actions, just like we are seeing today in the U.S.-China trade conflict. Speaking of China, I think the loss of the appellate body will also undermine our efforts to change China's abusive trade practices. I believe that the U.S. can do far more working with our WTO allies to bring cases against China for a variety of its unfair actions. And China has been reasonably good at complying when the WTO rules against it. But if we blow this opportunity up, if we blow up the appellate body. I'll close with this point. One of our panelists, Jennifer, recently wrote, there are very few champions in the U.S. Congress for the appellate body. If the appellate body crisis is to be solved, it is not likely to be at the behest of members of Congress or other political forces in Washington coming to the rescue. I hope today's briefing underscores that there are members of Congress who care about the appellate body because we care about America and about the global trading system that America has built from the ground up. With that, let me introduce our great panelists. You should have received a document with their bios. They'll each give short remarks, and then we'll open up to Q&A from me, any of the other members, and from the audience. We'll start with Jennifer Hillman. Jennifer is a senior fellow at the Council on Foreign Relations. She served as a member of the WTO appellate body from 2007 to 2011, and before that, she was a commissioner at the U.S. International Trade Commission. Then we'll hear from Stephen Coe, who is a partner at Aiken Gump. Stephen served as an associate general counsel at USTR and a legal advisor to the U.S. mission to the WTO. Next up, we'll have Linda Dempsey from the National Association of Manufacturers. Linda is VP of International Economic Affairs Policy at NAM, and she'll help us understand why the WTO is important to the manufacturing sector. And finally, our final speaker will be Jeffrey Schott, a senior fellow at the Princeton Institute for International Economics. Jeff has served in numerous positions in the government and academics and is a leading thinker on the WTO issues. With that, Jennifer, please take it away.
Thank you very much, and I want to thank you, Congressman Murphy, for inviting me here and really for your tremendous leadership on this issue. I think you have extremely well laid out the crisis that we're facing. So let me just start with a couple of the developments that came out of Geneva yesterday at the General Council meeting of the WTO. Two important things to me occurred. One is that the United States blocked a consensus to adopt a new set of operating principles for the appellate body that had been put together by the facilitator that was designated last February. New Zealand's Ambassador David Walker had been working for many, many months to develop this new set of principles. I think there was at least some degree of hope that these were approaching a consensus, but at the meeting yesterday, the United States blocked any consensus to adopt those new operating principles. And the second thing that happened was that the WTO's Director General, Roberto Azevedo, launched a new set of intensive, high-level consultations on how to resolve the impasse that will now occur at the head of delegation level. So again, at the ambassadorial level in Geneva. What that says to me is a couple of things. One, there's no question the United States now has everyone in Geneva's attention. It has maximum leverage right now to push for change to the WTO's dispute settlement system, but it clearly risks squandering all of that if it does not start engaging in real proposals to address its concerns. And that really is the problem, that nobody in Geneva knows what does the United States really want. Do they really want to just kill the appellate body? And this has been a long, drawn-out process to get us to the death of the appellate body. Do they want to go back to the old GATT system that we had between 1947 and 1995? And under that old system, if you didn't like the subject matter of the dispute, you simply blocked the creation of a panel in the first place. So you could never have a panel ever be formed to hear that case. And there are times when you listen to what the United States is saying, you think that is what they want. I mean, they clearly said when a lot of countries wanted to challenge the United States' tariffs on steel and aluminum under Section 232, the United States basically said, no, you shouldn't even form a panel on that because we think it's national security, it's too sensitive, it's too particular, you shouldn't have a panel. The second thing that happened under the GATT rules is if you didn't like the outcome of a case, you could block the adoption of the panel report. And that's also what the United States will get with the death of the appellate body, is if you want to block the adoption of a panel report, just file a notice of appeal. And it has the exact effect of blocking that panel report from ever being adopted. Or thirdly, does the United States want what it says, which is to go back to the rules as written in 1995? The problem for everyone is it's a little unclear, how do you get there, even if you agree that that's the goal? And second of all, there's a lot of skepticism. Is that actually the goal of the United States? So I want to take you up on your offer to just comment for just a minute about what does this mean, that the appellate body is dying today? And to me, it means three things. One is it means that every country is now going to have to decide what do they want to do about both the appeals that are pending now, today, there are 14 appeals pending, and secondly, what do they want to do going forward with disputes? I mean, I think each country is going to have three options in terms of what do they want to do. The first is the one that we've just discussed. You can go ahead and file a notice of appeal that will have the effect of blocking the adoption of that panel report, which is likely to invite the exact mini trade war that you just described. In other words, the country that wins says, okay, I'm now being blocked from my winnings, I'm going to impose tariffs. The other side says, no, you cannot impose tariffs while an appeal is pending, and they counter-retaliate. And you start to have a mini trade war over every single dispute. That's one choice. But countries could choose other options. One would be to use an arbitration process that is already out there in the rules, that is a process that's being promoted by the European Union, Canada, and Norway to effectively do the appeal under arbitration. It has a lot of pros. It has two downsides. One, it's case by case, which means will the United States agree to do it? Probably not. Second thing is an arbitration report never gets adopted by the dispute settlement body itself, so you don't have any help riding herd over compliance. You're on your own with an arbitration system. This third thing that countries might choose is to simply enter into a pact with one another that says, whatever comes of the panel report, I won't appeal. All right? Again, problem is it's case by case. So again, will the U.S. be bound? I don't know. The second, I think, thing that will come from the death of the appellate body is it's going to be harder to get new agreements on new rules, on things like digital commerce, on expanding the services commitments, on any other of the new topics that are there before the WTO to be decided, because there's a real concern. Why should countries agree to make new commitments if they can't effectively be enforced? And so it may have a real downside on the outcome of negotiations that are pending. The third thing that I think needs to be taken into account that will come is there is currently, to some degree, a chilling effect on countries engaging in WTO illegal behavior. Many countries that might want to go down various protectionist roads are sort of saying, no, we can't do that because it would violate our WTO obligations. Again, in the absence of a rules-based system, I think countries are going to be a lot freer to walk away from their WTO commitments because there's not an appellate body to really hold them in check. So what's the answer? I at least have been pushing the idea of a three-part solution to try to fix this. I'm trying to do that based on taking the United States at its word that what it wants to do is to go back to 1995. So if that's really what you want to do, here's a way to do it. My proposal would be first that you need to adopt these Walker principles, again, because they are an attempt to move the system back to the way it was written in 1995. Secondly, to me, you have to create an oversight committee to hold the appellate body to those Walker principles, that it effectively does an audit on an annual basis. Did the appellate body adhere to the Walker principles, yes or no? And you use a lot of that persuasive naming, shaming kind of power to make sure that the appellate body is, in fact, adhering to the Walker principles and that they are not, as the U.S. is contending right now, just words on a page. In other words, you make them a much more significant commitment. And thirdly, I think you need to see some movement in the Secretariat staff at the appellate body. This has become an issue, a little bit of a soap opera drama in Geneva this past week, but it's clear that you have gotten to an power imbalance between a staff that stays there for 15, 20 years and has great expertise and appellate body members who are part-time and come for 4 or 8 years. So you need a rotation in the staff and you need to do some changing among that staff itself so that they're not overly wedded to all of the past decisions and are not doing a lot of cutting and pasting from previous decisions into the next one, but we're starting really fresh. So I do think there are ways to fix this, but I think your sense of how urgent and important it is very real, and the concern is that right now the United States is fundamentally not engaged in the process.
Thank you, Congresswoman Murphy, for the opportunity to be here today. As someone who had represented the United States before WTO panels and the appellate body previously while at USTR and currently in private practice on behalf of other governments, I'd like to limit my opening remarks to the specific concerns raised by the Trump administration regarding the appellate body and the WTO more broadly. I'd also like to briefly comment on the importance of the WTO to the United States and the global trading system. The problem being raised by the Trump administration regarding the appellate body are not new, as mentioned before. Many of them are the same concerns raised by the United States when I was at the U.S. mission to the WTO in the early 2000s. They include, one, the appellate body reviewing not just the issues of law, but issues of fact, what the Walker process calls the scope issue. Two, the appellate body making decisions on issues that were not raised on appeal, what the Walker process calls advisory opinions. Three, the appellate body coming up with new rights and obligations or new tests that are simply not in the WTO agreements. Walker calls that overreach. And four, the appellate body citing to its own previous reports and not to the text of the WTO agreements for the legal basis for its decisions, what Walker calls the precedent problem. So in 2002, the United States and Chile submitted a joint proposal to the WTO entitled On Improving Flexibility and Member Control in WTO Dispute Settlement. The proposal included requiring the appellate body to issue interim reports, just like panels currently are required to do, so the parties to the dispute can delete by mutual agreement, any finding in the reports that are not necessary to resolve the dispute, and allow the parties to retain control over the terms of reference of the appellate body. The proposal also included a mechanism that allowed the WTO dispute settlement body to adopt parts of the appellate body report, but not others, so as to ensure that only the relevant and proper reasoning and findings were accepted. And the proposal included the ability of parties to suspend appellate body proceedings by mutual agreement, just so as they can do now in panel proceedings, if they do not like where the appellate body is going, and so they can try to resolve the dispute bilaterally if they so choose. Now, as for the other two procedural problems that the Walker process has raised, that's one, the appellate body members staying beyond their terms, and two, the appeals lasting longer than 90 days. These are issues that involve member control as well. The WTO is intended to be a member-driven organization, So even the working procedures of the appellate body should be decided by the members, which is currently not the case. Whether the appellate body member is able to stay beyond his or her term in order to finish a particular dispute or appeal should be the decision of the membership. Whether the appellate body is permitted to take more than 90 days to issue its decision, that should be agreed to by the parties to the dispute. So you can see these problems are not new. The United States has tried to fix these issues before through proposals such as in 1992, or by blocking reappointments of WTO appellate body members for the second term, or now by refusing to appoint new appellate body members. Some ways are better than others. One other proposal I think worth mentioning is to make the panel interim review process more robust. Currently, parties are not utilizing this process because panels are loath to make decisions or changes to their own reports. But if this review process were undertaken by other legal experts, then query whether this would result in less use of the appellate body. My own opinion is that these old US proposals could be part of the solution of the current problems. The WTO membership and the WTO Secretariat were not inclined to consider these proposals before, and maybe they would be open to considering these proposals now. However, the issue with the WTO, and as Jennifer mentioned, is not really limited to the appellate body. As Ambassador Robert Zellick remarked recently, the main problem is that current WTO rules don't cover many US needs. There are new trade issues and barriers that just did not exist in 1995 when the WTO was first established. The WTO membership needs to keep up by creating new rights and obligations, but agreement among 164 members is difficult. Some have suggested seeking plurilateral agreements first among like-minded countries and then growing consensus from there. None of this means that the WTO is broken and cannot be fixed, however. The WTO is a relatively young organization, and all organizations must be reformed every several years in order to remain relevant. Regular tweaks should be made to close loopholes, to increase efficiency and ensure effectiveness. It's time for the WTO to return to its roots, which is to negotiate practical trade rules and to resolve trade disputes. It would be unwise to throw the baby out with the bathwater. The WTO has served successfully as the foundation of the rules-based international trading system for 25 years. It has promoted market access, prohibited discriminatory and other unfair behaviors, and required transparency where there were none before. In this regard, the U.S. has benefited from the WTO. It has used the system to lower tariffs and remove non-tariff barriers, and challenge measures adverse to its businesses and workers. And despite the shortcomings of the appellate body, the United States has won a high percentage of its disputes, as Congresswoman Murphy mentioned earlier. From a broader standpoint, the WTO's success also lies in its ability to moderate the trade tensions through the rule of law. This is no small feat. Promoting the rule of law globally will lead to predictability in international trade while avoiding broader geopolitical tensions. Let me stop here. I'll look forward to questions you might have.
Thank you, Stephen. Linda?
Thank you so much, Congresswoman Murphy and your colleagues for holding this very important panel discussion to discuss the current situation and the future of the World Trade Organization. I come to you today on behalf of the National Association of Manufacturers, the oldest, largest manufacturing business association in the United States. We represent thousands of manufacturers in every state and every manufacturing sector, 90% of them small and medium-sized companies. And then the millions of workers that they support who make things in America. With the world's most productive manufacturing sector in the world, but a domestic economy that only represents about 10% of global consumption, manufacturers in America need to be able to have access to the billions of foreign consumers and the 90% of global consumption outside of our country. Many of our manufacturers rely on foreign inputs that help them innovate, become more competitive, and produce more and better paying jobs here in our country. Notably, manufacturers in America export about half of what we produce here, supporting about 6 million of the 12 million men and women who work in manufacturing. In order to preserve and build on that success moving forward, manufacturers need fair, binding international trade rules, which means that the world's premier international trade rulemaking, negotiating, and enforcing body, the WTO, must be revitalized and modernized. Manufacturers have long been at the forefront of supporting a strong, respected, and fair rules-based global trading system. Under the current WTO, manufacturers have benefited broadly and significantly from the substantial reduction in global tariffs and trade barriers to the adoption and enforcement of stronger and fairer standards that the WTO has implemented. Numerous policies since it was established in 1995. Manufacturers have also clearly benefited from the WTO's strengthened and binding dispute settlement and appellate body system, which has enjoyed strong support from Democratic and Republican administrations. Yet the rules-based WTO system has not kept pace. It has not kept pace with industry or technological developments. It has not kept pace with new and pernicious trade-distorting practices. And it has also not updated and improved or addressed issues with its own processes to deal with systemic problems that require improvement. And so the WTO finds itself at a crossroads and without action, increasingly in a dire state of paralysis. There are 4 issues in particular that are of deep concern to manufacturers. First is the issue and the need to deliver broad-based trade liberalization. The WTO has been largely unable to do so since it was established more than 25 years ago. There have been a few sectoral agreements. There's been the trade facilitation agreement, all very important, but not the broad-based trade liberalization that manufacturers have sought. As a result, tariffs, trade barriers that were locked into place in 1995 are largely where they were, except in those sectors, or except where countries have gone forward and negotiated separate bilateral regional trade agreements. Our hope for even a broad environmental goods agreement to eliminate tariffs on those products that are important for not just manufacturers, but broader interests, was unable to go anywhere. Second, the WTO must modernize its rule book. It has been unable to modernize or adopt new rules in important areas that are critical. Examples include the rules on digital trade, of course, that we talk about, but also state-led competition, distortive subsidies that have gotten worse, not better, and other issues. Third, the WTO must enforce that rule book. Countries small and large too often ignore WTO requirements with impunity. This includes everything from failing to notify trade barriers to taking actions clearly contrary to WTO rules. Fourth, and the subject of this discussion, but these other issues obviously pertain to it, it must improve its enforcement tools, most notably the appellate body system. The WTO's dispute settlement system has long been overloaded with small concerns that have grown larger, particularly with the blockage of the appointment of new appellate body judges by the U.S. government. We are now left with an entire appellate body system in a state of paralysis. So the ability to enforce effectively and in a binding way the many areas where countries fail to live up to their commitments has largely been rendered ineffective unless individual countries agree, as Jennifer was talking about, to find another way to appeal or not appeal cases. There can be no question that the WTO system is in need of revitalization and modernization, and Jennifer and Steve, and I know Jeff will as well, talk about some of the ideas on how to address some of the areas where we need improvement in the appellate body and elsewhere. We are pleased to see some of the progress in Geneva. The U.S. has made some important proposals on areas such as notification of trade barriers, improving criteria for countries designating themselves special and differential treatment, and transparency in dispute settlement. In the appellate body process, we've obviously seen the Walker proposals, which we believe are a very important step forward to improve the system, but clearly do not represent enough yet for our own administration. Now is the time for the United States, alongside its major trading partners, to engage quickly, proactively, concretely, to develop real solutions here that can solve this deadlock, to ensure that the appellate body meets the goals when it was established to provide an effective and binding form of dispute settlement on the agreements and commitments that were actually negotiated. The path forward is not an easy one. The WTO and its 164 members do not easily see eye to eye, and decision-making is oftentimes blocked by one or a few members. But manufacturers in the United States are absolutely committed to being allies in the modernization and revitalization process. Globally, more than $10 trillion in manufactured goods cross borders every year. That's $1 billion every hour. For manufacturers, we need a functioning rules-based system, one where enforcement is binding and fulsome, but that enforces the rules that have actually been agreed to. And so we look forward to working with you and others for that system, but there is no time to waste. Thank you.
Well, thank you very much, Congresswoman Murphy and your colleagues. This is a very important meeting, and I think your interest in this subject is vital to getting a deeper discussion and understanding of the importance of having a rules-based international trading system for the U.S. economy. I'm not a lawyer. I have represented the United States at the negotiating table in Geneva and written international trading rules that have benefited U.S. firms and workers. And so I value the contribution that a rules-based system can make in helping businesses, that Linda represents and others, provide opportunities for American workers. And that is not what is under consideration in the administration today. And that's the big problem. We have legitimate concerns with the international system as it came out of the Uruguay round in setting up the World Trade Organization. These are longstanding concerns. It led to the initiation of new negotiations, both to reform the dispute settlement rules and to update the WTO rulebook. And in both cases, the results have been very limited. And so the U.S. frustration that the rules haven't been improved and the rule book modernized to reflect the current challenges of doing business in the 21st century, that's needed. Previous administrations have also blocked the appointment of judges, but the big difference has been that in the past, we have done that to send a signal of the need to accelerate negotiations. And today, the Trump administration is using it to actually take a sledgehammer to the appellate body itself. That's much different than what we had in the past from both the Bush administration and the Obama administration. The idea was to deal with the appellate body in a way of accelerating the reforms. What I'm concerned about is that the current administration feels that the problem is now fixed. That, as Jennifer noted, because there are no new, with no new rulings and the U.S. having the ability to block any decisions taken by dispute panels if they go against U.S. interests, there isn't a concern about judicial overreach anymore because we have the ability to stop it when it affects U.S. policies. But this fix inevitably will cause bigger problems. You've noted it in your introduction, and the other panelists have noted it as well. Bigger problems for the rules-based world trading system. And I should note that many of these rules are based on U.S. law and practice. Basically, the world, as it has evolved in the post-war era, looked to the United States for the template for establishing new rules to support trade liberalization and promote economic growth. And we took the lead in leading the world economy into new trade reforms in various GATT rounds and in establishing the WTO. We seem to be forgetting that the rules that we seem to be walking away from are the rules that we actually live by here at home. USTR seems nostalgic for the GATT era. Jennifer mentioned that as well. The GATT era even though I tried to improve things at that time, was not the great achievement of the post-war period. It had to be improved, and improvements were made. But in dispute settlement, the GATT era was a failure, because what happened at that time was the U.S. could block decisions if any decision went against us, but so could the European community. And when push came to shove, there were big cases involving very big U.S. programs that were under dispute between the U.S. and Europe, and they couldn't be resolved. And the frustration grew in Congress to the extent that by the mid-1980s, members of Congress said, we have to have binding dispute settlement. And so the 1988 Trade Act put as one of the top U.S. priorities for the Uruguay round of multilateral trade negotiations to install this system of binding dispute settlement and to put in the appellate body to ensure that matters of fact and law would be effectively followed. That seems to be forgotten by the legal scholars at USTR. They don't have the proper historic perspective and recognize that the United States was the one supporting this type of system, and we did it because it benefited U.S. firms and industries. They seem to be, our trade officials seem to be dismissive of the systemic costs, or in other words, the damage done by disabling the appellate body. You've mentioned it, and others have mentioned it. It will be harder to get support for new trading rules, for initiatives already underway or those that we recognize are needed. Why negotiate new rules if the old rules aren't being enforced? And then there's doubt about the enforcement of new rules. Congress has been absolutely right in saying if we're going to go through this process of having new trade agreements, they have to be enforced. Well, that should apply to the trade obligations that apply to 163 other countries. We seem to be forgetting that. Or perhaps the administration thinks they can get enforcement out of Europe and China and other countries by dealing with these countries bilaterally. Well, it hasn't worked so far. And we've seen this in episodes of what I would call vigilante protectionism, with tit-for-tat tariffs that hurt our economy and hurt the economy of our trading partners, both the targets like China and our friends who are hit in the crossfire of the trade war. Another damage, which seems to be underappreciated, is that U.S. cases against foreign malpractice would be blocked. So when we have a legitimate concern against China, as we've had over 20 times in the WTO, and China has been found guilty, we've been able to get compliance. But China, starting tomorrow, can block decisions that the U.S. wins in the WTO by taking the same course that USTR would take against decisions against us. So it's not a healthy solution, and one where if the ultimate objective of the U.S. officials is to maintain the right to have the final say on whether we are in compliance or not, and not have an objective binding system of litigation, then everyone else is going to follow, or the major trading countries are going to follow the same example. Stephen said that's throwing the baby out with the bathwater, and that's right. The U.S. gains so much from having this legal system, this rules-based system, that it's crazy. It's literally crazy to think about throwing it all away just to solve a problem of judicial overreach, which, if you look at where it is focused on, is mostly in the area of the application of U.S. anti-dumping and countervailing duty rules. There are differences. Many countries have a different interpretation of the obligations negotiated in the Uruguay round than we do. panels have ruled in favor of the United States and ruled in favor of other countries. The appellate body has reversed many of the rulings in favor of the United States, and I think that's a major source of concern. I would think that the simplest thing, and I was inspired by a paper Jennifer wrote a year and a half ago about this, is to basically say, if the problem is the concern about appellate body reviews of anti-dumping and countervailing duty cases that have already been adjudicated in the United States and in a dispute panel, then basically waive the right or exempt those types of cases from appellate body reviews and just leave them to the binding dispute settlement decisions, many of which favor the United States. That is, to be sure, not a complete solution, but it does carve out, in a very concrete way, what the United States would gain and eliminate sources of concern. But if the U.S. position is going to be back to the rules as written, as a trade negotiator, I can tell you that there is never one interpretation of back to the rules as written, and we will continue to have this dispute. So I thank you for your attention, and I thank you very much for having this meeting.
Thank you very much. I'd love to ask just a couple questions and then yield to my colleagues for their questions. It sounds to me generally that there's consensus on this panel that the WTO should be reformed rather than to be allowed to allow the appellate body to wither on the vine. And we've had a great in-depth conversation about the trade implications. I was wondering if one of you could talk about what the demise of a rules-based trading system would mean to, say, a Central Florida mom shopping for groceries, or a small business owner in Orlando who's trying to grow his business and hire more workers, or even, say, a young UCF student who's heavily dependent on technology and looking into building for a career in the future. What does this demise of a rules-based trading system mean for those individual Americans?
Well, I'll start. I think the biggest implication is that what it means is that what they're looking at is chaos and uncertainty, and both of those have huge costs. And I think the costs fall most heavily on the kind of constituents that you're describing, the smaller and medium-sized enterprises that are going to have trouble. Why do I say that? Because one of the clear things that the WTO gets you is, among its bedrock principles, are these notions of most favored nation, and that countries have to live with their binding tariff commitments. So again, if your exporter is used to always being able to export into Europe or Latin America, and they know what the tariff is, and they know that they're guaranteed to get that product in there and pay only X amount of tariff, the moment you don't have a binding dispute settlement system, those other countries can impose tariffs on the United States for any reason, just because they don't like Americans, they don't like the Trump administration, they don't like something. You're walking away from this commitment not to discriminate against Americans. Well, now your exporter has to face, I've never had to pay tariffs before. I don't know how to finance a tariff. I don't know what a customs broker is. I don't have a financing arrangement. I don't have a bonding agent that I can go to help me with those duties. And again, for that small or medium-sized enterprise, those are real issues for them, that they're all of a sudden facing it. And they're scrambling to figure out, what are these rules? I've never heard of them, and I don't know what to do with them. And the problem is then nobody can answer their question, because it all becomes a matter of uncertainty, because you don't know, because that other trading partner has decided for whatever reasons that they're not going to be bound by the rules either. And that fear of uncertainty and chaos, to me, is creating an economic drag on economic growth, not just here, but throughout the world. It is going to just overall dampen economic growth, because nobody wants to make an investment into an uncertain, unrules-bound world in which they don't know what's going to happen to that investment. So that is first and foremost, I think, the implications for, and again, it tends to fall more heavily on the smaller and medium-sized enterprises that have a lot harder time hiring the lawyers and the bonding agents and the customs brokers to deal with the chaos that gets created by walking away from a rule system.
I could just add to that in a very real way, we spend a lot of time talking about tariffs, right? That's a lot of what the pre-GATT and the WTO has negotiated. If we didn't have a rules-based system with binding enforcement, other countries could just stop our ability to export. Or, you know, when I think about something like the rare earths case or raw materials cases that we brought against China, where China wanted to limit its export of critical minerals and other natural resources, we were able to use the WTO to ensure that they had to sell that around the world in a fair, non-discriminatory way. So it actually, I think, goes well beyond tariffs. When you talk about the technology person, you know, young student developing his own technology business, this is where I think, you know, some of the comments of the panelists, does the lack of a binding dispute settlement stymie the ability to negotiate? We don't have the digital trade rules that the USMCA just is going to put into place, really good rules that will really help individuals, businesses, workers in all sorts of ways. It could be an entire session itself. But we don't have those rules at the WTO. So, you know, it's important to get there. But I do think it's important to, I think you said, Congresswoman, we all agree there's some problems here. You know, I, for one, am going to take this administration and other governments at their word that they want to get to a solution, that is a binding appellate body that works. Obviously, there's different views. How can we all get there?
Can I just add one quick point on this? If you ask a businessman what he needs from the trading system, he will say, I need predictability. Just tell me what the rules are, whether they're help me or not. If I know what the rules are, I'll figure out a way to make it work. If you don't know what the rules are, or if you think the rules are going to change and upset your trade and overall business strategy, then you're going to have to sort of do contingency planning. This is what U.S. businesses are facing right now in the U.S.-China conflict. They don't know what's happening, and so the investments that they are making, if they are making the investments, are taking into account possible scenarios that might not work. They're going to reduce the productivity of those investments, and therefore the long-term growth. So we're paying a tax because of this uncertainty on future growth, and that's going to affect the opportunities for output and employment in your district and around the country.
Thank you. Just to follow up a little bit, because you've all highlighted the need for the creation of new rules, whether it's digital trade or otherwise. And historically, the U.S. has been a leader of developing these rules, as Jeffrey, as you mentioned. Do you think U.S. leadership is waning at the WTO? Are there any indications that the U.S. is leading in attempting to establish the new rules that would fit the modern economy that we have, that, Stephen, you said the WTO falls short of regulating?
I think the United States is leading in a number of areas in Geneva. And the question for me is whether this effort to block the appellate body is effectively undermining that leadership. So yes, the U.S. is leading, I would say, in these digital trade negotiations. There's no question that the United States is one of the leading drivers of putting proposals on the table. As others have mentioned, the U.S. is leading the charge to try to change the way in which subsidies are notified to the WTO and the penalties for countries that fail to do notifications. The U.S. is leading the way in terms of trying to increase the degree of transparency. The U.S. is leading on this issue of how to treat developing countries and whether they should continue to be allowed to claim developing country status. So in many areas, yes, the United States is leading. And my concern is that I do think that leadership right now is being seriously undermined by the level of ire at the United States over this blocking of the appellate body. Because, you know, the argument of all of these other countries is we have a right to the appellate body. I mean, the rules say very clearly that the dispute settlement body shall appoint members to the appellate body. And here you are, United States, one sole country, blocking the right of 163 others to have the system that they believe that they are entitled to. And there hasn't been any indication by the United States that they're prepared to engage in any kind of a discussion about that or any trade-off to try to exchange some reforms of the appellate body in exchange for the United States getting some of the things that it may want in these other areas. So I think, yes, leadership, but clearly a cloud over it.
If I could add a little bit to that, I mean, there's a question of when you lead, who's going to follow you? And I think before, the U.S. have always felt pretty comfortable when it leads, that there will be people who follow. There will be people who are listening. They will take a view, maybe not on the same side, but they will take what the U.S. says into account. I think that's becoming less and less the case. When the U.S. talks now, some of the immediate knee-jerk reaction is to discount that or to challenge it, and that's unfortunate. And it used to be where if it was, the U.S. and let's say the EU talking, people get the sense that you're gonna get the fair shake from the U.S. You may not agree, but you're gonna get the fair shake. You want to know what they're talking about. You want to know the rationale behind it. With the EU, sometimes you feel like they're playing games and what is really the undercurrent. I think now things may have switched a little, and I think that's problematic.
Thank you, and I'll yield to Mr. Cooper.
Thank you for this excellent hearing. Today's news has both good news and bad news for folks who like trade. First, on the good news side, Linda referred to it obliquely, USMCA looks like now it's going to happen, which is maybe a modern-day miracle. But the bad news is that I read today that China is planning on banning any U.S. computers or software in the entire country. So let me ask a very simple question. Is that Chinese ban a WTO violation?
Again, I'd have to see it, but my off-the-cuff reaction is yes. You're not allowed to ban imports coming in if you, again, and you'd have to look very clearly at what are China's commitments. So if China made commitments, and again, the commitments would be both in its tariff schedule and potentially if there are services connected to that in its General Agreement on Trade in Services schedules. So the question would be, did China already commit under WTO rules to open up its market to trade in those products? So off the top of my head, I don't know exactly what China's commitments are. But the first thing you would have to look at is what exactly did China commit to, both in terms of a trade in a good and in a trade in a service. And then thirdly, what are the intellectual property rights that may be connected to each one of those goods? So you'd have to look in all three buckets, if you will, to figure out what are China's commitments. If China committed to permit the trade in those, then a ban that singles out the United States as saying we're not going to permit trade in those from the United States would be a violation. And the problem for the United States is if China did not make the kind of commitments that it needs, that's another one of those issues where we need to then get back to the negotiating table to make sure that we are getting the kind of commitments that we want for market access in those that then cannot be violated.
Mr. Cooper, it depends on what purchases are being affected. If they're purchases by government agencies, then they are covered by the government procurement agreement, but China is not a party to that agreement, and so does not have obligations right now under the WTO. We've been trying to get them to put forward a substantive enough schedule of obligations to join the government procurement agreement. That hasn't happened yet. And so it could be that everything Jennifer said is right, and if it's just applied to government agencies at the national and subnational level, then it is not a violation. And so that's one of the reasons why you want buy-in on these rules and the ability to enforce them.
And I was going to make a similar point to Jeff's because we do understand that it probably is limited to government purchases. But it does raise some concerns because this was evidently a policy that was agreed to by China, not just in the last 2 days, but several months ago. And so the transparency obligations that we have in the WTO, this may not be a direct violation, but it should be, right? We should be improving the transparency notification obligations so we know about these types of things before they happen, and obviously would be of great concern. And so this is yet another area where we want to see more coverage, more trade liberalization, more rules being negotiated. And that, in some sense, would help take the pressure off the enforcement. Too often, I think, cases and efforts are made to go through the dispute settlement system when really what we need are new negotiations to develop this. But let me just say, manufacturers are pretty excited today. We are happy to see that there is now a pathway forward on the USMCA and appreciate all the work of many of you, certainly on the working group and beyond, and the administration, and look forward to getting certainty and predictability back in North America, our largest trading relationship.
Let me say that there's no simple answers to illegal questions, and we have lawyers to thank for that. Jeff is right that it's, probably covered by government procurement, and therefore China is not a party to the GPA. But if it were broader than that, if it were government purchases for commercial use or for the resale, then that just doesn't get covered by the GPA and broadly covered by WTO. The one point I'd like to make in addition to this is I think the way I read what China is doing is it's sort of a reaction to what the U.S. is doing in terms of calling something security, national security issues, and whether it's truly a security concern that they have, because the WTO does have this broad exemption to ensure that if you are taking action for purposes of national security, that your otherwise violative act would be exempt. But the real question is whether there is true security or not. I mean, that security card in the last 2 years has been overplayed, and countries are starting to sort of take that on and doing the same things I think this administration is doing.
Ms. Rice?
Thank you, and thank you for doing this hearing. This is incredibly important for us to be speaking about this topic, especially right now. Jennifer, you spoke before, and I'd just like you to expound on steps that the U.S. could take to reach out to certain other members of the WTO to see about working out some kind of a path forward. Just if you could just expound on what that looks like, number one. And then Jeffrey, all of you, from what we're hearing from all of you, it seems that the Trump administration seems to be totally unwilling to exist within a system where it could possibly lose. So are there any fixes that you think this administration would be willing to accept? And again, one of the most disturbing things that all of us should be thinking about is the ire, Jennifer, that you talked about, that is directed towards the U.S. and our ability to have our word be relied on. And are we going to miss this opportunity, and are the rest of the WTO just going to say, forget about America? I mean, the reason why USMCA was so important is because we were at the table indicating what we were willing to accept. We were driving that initiative, and that's why it's so important for us to be at the table. And so just the disturbing trend or direction that it seems that the U.S. is taking vis-a-vis their ability to have their word be relied upon.
Well, thank you very much for the question, and I think your interpretation and instincts are exactly right. I mean, that is the concern that I think everybody has. In terms of whether there is a coalition or a group that could be put together to try to think about the appellate body, the problem has been there it is the United States alone that is the one that is blocking the appellate body, and the United States is sort of alone saying nothing will satisfy us. And an awful lot of what the United States is saying is that they won't even engage in this conversation until there is an answer to the question of why did the appellate body feel entitled to stray from the rules. And to be quite honest, I think a lot of other people in Geneva are sort of asking, what difference does it make, what the answer to that question is. There's a lot of, the honest answer are, it depends on the case. Sometimes it was administrative practicality. Sometimes there wasn't enough time to get the translation done, so the case took longer than 90 days. Sometimes, so each individual answer of why did the appellate body exceed its 90 days or do this or that, the answer is sort of, it depends. And I think the rest of the world is getting very frustrated that they're not getting any response other than we have to start with this question that nobody can understand what's the point of it. On whether there's a coalition, the problem is now, to the extent that there are coalitions forming in terms of a reform, they don't include the United States because the perception is that the United States doesn't want a solution on this issue of the appellate body, I think for the exact reason that you describe. In other words, that the U.S. is seeking a system in which it can never lose. And obviously for all of the other countries, part of the point of wanting to have a dispute settlement system is that they have the ability to bind the United States to its commitments. They can't make the United States make a commitment that it doesn't want to make, but they would, in theory, have the right to bind the United States to its commitments. So again, I do think the European Union, Norway, and Canada have formed a coalition to try to create this arbitration process instead of the appellate body system. Other countries are slowly starting to go down the road of forming these pacts where you would agree not to appeal a decision so that you wouldn't have the effect of binding, of breaking up the system. You would simply agree ahead of time, whatever the panel says, I'll live with it, I won't appeal my cases. Again, you could see more and more countries joining that kind of a pact as a way to say that there is a binding dispute settlement system. Again, the problem is it leaves out the United States. And so for the United States, then it does beg this question of when it comes to we want to enforce rights that we've won against China or others, again, why would China or anyone else join a pact if the United States hasn't agreed? So that's really where we are. And again, the concern I have, and I think that what you've heard from this panel is the urgency is now. Okay, now the United States, if your goal was to kill the appellate body, today is victory day for you because the appellate body is now dead. And so the question is now what? And I think for the next few months, and certainly leading up to the WTO ministerial, which is in June of this year, again, every 2 years there's a major ministerial meeting. If the United States now seriously engages in these discussions, then I think you can see coalitions forming that would join the United States, because it is not the case that no one shares some of the United States' substantive concerns. A number of countries do, but no one shares our tactics. And so the question is, can we move the U.S. off of those tactics in order to pick up some of the allies that do share some of the substantive concerns about the appellate body? And until and unless the U.S. indicates that they're prepared to move at all, I think it's hard to get those coalitions together.
I've tried to be optimistic throughout my career on how you can get things done, but I was trained in the U.S. Treasury where I was told always to start a discussion by saying no. And I think that's the approach the U.S. is taking right now with regard to reform of the dispute settlement system. I suspect that 90% or more of the problems cited, the procedural issues, would be amenable to a resolution by the United States and other countries if there was a satisfactory result on judicial overreach. But Ambassador Lighthizer understandably is saying, I want my priority dealt with first. I don't want to make an agreement on all these other issues, and then you come back and say, well, we'll talk about your issue later. So he's holding essentially the procedural solutions and many good suggestions that Jennifer and Stephen and Linda have put forward. They're being held hostage until this fundamental issue is resolved. But there's still the question of whether he really wants to resolve it. And so when I put forward my proposal based on Jennifer's inspiration, but she doesn't take blame for its defects, I thought this is something to show a concrete change, but it's probably going to be insufficient. And if the negotiations are limited to dealing with fixing the dispute settlement system, they're going to fail. Because the United States will say, we're going to do the rulemaking outside of Geneva, and we'll do our enforcement unilaterally. That's not a winning strategy. even in the rulemaking on digital trade, we've gotten acceptance from Canada and Mexico and Japan, but we have big problems with Europe and China. And a system of rules on digital trade is not going to work unless they cover Europe and China. So the rulemaking approach really has to have, if not buy-in by all 164 WTO members, it has to have the major trading countries that are going to be affected and disciplined by the rules. And there, I don't know if the current administration has a strategy or a priority of doing that. I don't see any priority, any strategy of WTO reform in the current administration. I think they're focused on their bilateral relationships.
If I could, I just want to challenge briefly this notion that the U.S. is seeking a system in which it never loses. The WTO rules, the WTO agreements are not all just trade liberalizing. There are agreements that allow for legitimate protectionism, such as anti-dumping, countervailing duty agreements, the safeguard agreements. I mean, it is supposed to be a balanced package, one where every government tries to liberalize and tries to protect. I mean, they may have different, on the spectrum, they may vary in terms of where they lean towards, and they may change depending on which administration is in power. But there is that sense of balance that every government has to do, and the WTO agreements have that balance. I think what is problematic and one of the legitimate concerns is that when you try to use the AD agreement or the SCM agreement or even safeguards, which is really kind of an obvious example, there's never been a case in which a safeguard was found to be legitimate, found to be consistent with WTO rules. How is that possible? That is just, it seems like it is skewing too far to the other side. Now, things have to be challenged and they have to be tested, but I think the WTO, just as a general matter, has been, the appellate body even, a little bit too far towards liberalization, and they should probably think more about trying to be more balanced.
I think there's two things from where we sit in the manufacturing sector that we think it's important that we're talking about with our international business colleagues, the administration, of course, but also other governments. And I do think there are a lot of other foreign governments who agree with the critique. There's the issue of why the WTO is important for productive activity, for commercial activity, for job growth, for the elimination of poverty, for all of that. The rules-based system, including a binding dispute settlement system. But there are also flaws and problems with the system. My colleagues highlighted many more in the appellate body system. And there does have to be that recognition. I think there has been a growing recognition of that. I think there are a number of governments around the world who agree and are trying to solve it. But it's keeping those 2 points front of mind for all parties and urging them to get back to the table. Our government, other governments may have predilections here or there. I'm not going to try to get into their head as to what their ultimate objective is. They're all negotiating, right? But we need to focus on what are the outcomes and why we're doing it, right? We're doing it for those workers that the Congresswoman talked about. We're doing it to have the certainty and predictability so we have a viable, growing business sector, so we're producing more and better jobs and opportunities and prosperity, not just here but around the world. And I think we've all got to come at this, and certainly our commitment as manufacturers is to come at this with that sense of urgency on both sides of the coin, both in terms of where we need reform, revitalization, modernization, but also where we need a system that works, that's credible, that's respected.
Thank you, Mr. Cooper.
Thank you. The reason that the Trump administration has taken this destructive and unilateral move must be some company or industry or industries that have complained very loudly and that the Trump administration has listened to. Who are these folks?
I don't know, but I would suggest that probably at the top of the list would be the U.S. steel industry. because of all of the industries that has been the largest user of the anti-dumping, countervailing duty, and safeguards cases. It would be the steel industry. More than 50% of all anti-dumping cases in the United States involve steel products. And again, their objection is to a series of decisions by the appellate body, and I do think it's important to emphasize by the appellate body, that in their view have taken away rights that the steel industry and other industries that use these laws had when the WTO agreements were written in 1995. Again, in the anti-dumping world, a whole series of cases at the WTO that again, in the words of the USTR, the United States' right to engage in a practice called zeroing, which is a way in which anti-dumping duties are calculated. And if you can engage in this practice of zeroing, the margins of dumping are higher, right? And the steel industry generally, again, has brought 50% of all the cases in the United States, and they want those higher margins. So the WTO handed down a whole series of rulings that effectively said you may not engage in this practice of zeroing. So again, that is an immediate signal to them of you've taken away my right to zero. Similarly, in the subsidies area, one of the issues was whether or not you could go after the subsidies that were provided by state-owned enterprises in China, for example, a steel industry that turns around and provides that steel to a pipe and tube manufacturer in China, and those products then come into the United States. The subsidy went to the steel company. What's coming in is pipe and tube. And so the question is, can you go after those subsidies? And again, the appellate body ruled that for it to be a subsidy that counts for countervailing duty purposes, the grantor of the subsidy has to be a government or a public body. And they then defined public body to be an entity that exercises a governmental function, and then effectively ruled that that steel company, even though it's 100% state-owned company, doesn't qualify as a public body, and therefore you cannot bring this countervailing duty action against that pipe and tube coming in. So again, a huge push back against. And then thirdly, in the area of safeguards, again, the appellate body read in this requirement that you have to show that the increase in the imports was as a result of unforeseen developments. And that in and of itself made it very difficult to use the safeguards laws. So I would say in general, it is this group of companies led by steel, but a lot of others that are significantly reliant on U.S. anti-dumping, countervailing duty, and safeguards laws that feel the most aggrieved by the decisions of the WTO appellate body. And are they right to feel aggrieved? My sense is probably yes. I mean, there are a lot of those decisions that did, in fact, push against at least what the expectations were by the United States when it entered into the WTO agreements in 1995. The expectation was that we would continue to be able to zero, that we would be able to continue to use our safeguards law, that we would be able to go after subsidies, including subsidies by state-owned enterprises. So all of those expectations were very much dashed by these decisions by the appellate body. So I think the users of the trade remedy law are leading this charge to say that the appellate body deserves to be condemned and killed off.
I would just say, look, I'm not aware of any specific industry that has sought the panel blocking or anything like that. I think Jennifer and Steve and his rendition of the safe, that the no safeguard case ever brought has been upheld by the appellate body. I think it is in this area, and Jeff, of course, mentioned it as part of his suggested solution, in this area of anti-dumping, countervailing duties, safeguards, import sensitivity, which was one of the tough issues negotiated during the Uruguay round. It was one of those endgame pieces. What is the balance of when can the U.S. use these laws? Other countries have these laws. China uses these laws a lot. India uses these laws a lot. And so that's one piece. The other piece is these issues with precisely these points that Jennifer was raising have been raised very early on by the Bush administration, by the Obama administration. It is not just a symptom of this administration in terms of the level of concern.
But in terms of the tactics this administration has used to blow up the appellate body, it seems like, regardless of the merits of the concerns of the steel and other industries, that those interests have been allowed to trump all other industries and all consumers in America. Because trade in general is good for everybody.
You're absolutely right, Mr. Cooper. The steel industry has been active in litigation for decades and decades, long before the WTO. Even in the Carter administration, there was a trigger price mechanism that provided protection for domestic steelmakers. But in all of the other administrations, there was a concern for reinforcing and strengthening the rules-based trading system. And in this administration, I'm unclear whether there is that commitment because of the focus on dealing bilaterally and trying to enforce unilaterally.
If I may interject here, and this will be my last point, I'm deeply worried that as we blow up the WTO, that we're really throwing everyone in the world, and every industry in America and every consumer, basically into more of a China-based trading system. Because somebody is going to call the shots, and it's either the West or increasingly China, right? So we blew up TTIP, we're blowing up WTO. We're just asking all the folks who've been alienated by this decision, the 163 other countries who are upset with us, we're asking them to go elsewhere. And isn't it ironic that because we're afraid of China dumping, now we're inviting the rest of the world into a China regime trading system?
I don't think there's any doubt that one of the players that's filling the leadership vacuum when the United States exited is China. And I think there's a lot of concern that we're headed down a very sort of bifurcated world in which China, again, you brought up in your first question the issue of communications and computer equipment. A real concern that we're headed down a path in which there is no operability as between a China-based information communications technology computer system and, if you will, the Western system. And that we're going to start in really parting company with China going down one road and the United States on another road, and then put Japan and Europe and others in this extremely difficult position of having to decide, kind of which system are they going to. And I think your question also, to me, goes to one of the issues, which was the United States used to, I think, very comfortably carry the moral high ground at the WTO, that we had the most open trading system in the world. We had the most transparent economy in the world. We were the leaders in every way of a rules-based system. And the moment we start engaging in all of this unilateral tariffs on steel and aluminum in the name of national security, again, against China, we start engaging in a lot of unilateral behavior. What you've then allowed is China to claim the high road, that China is now perceiving and arguing within the WTO context that it's China that is the rules-based system and China that is carrying that moral high ground. And whether they deserve it or not, that is the vacuum that China is prepared to step into.
Yeah, I think without the global trading system and the rule-based system, what you're going to see is just survival of the fittest, and that there's not going to just be one. It's not just two players out there. There's going to be multi players sort of getting at and going after each other. In fact, we just heard this morning that the EU is preparing to create a unilateral system of its own, like its own 301, to come after the U.S. So, everyone is gearing up to go at this alone. The power of the multilateral system really is the ability to be able to ensure and to promote the rule of law, and to also ensure that there is no retaliation. Because if a group of countries agree to these things and they abide by it, there's a lot less chance of them, of the loser, let's say, of a dispute to come after you one by one. It's just not possible. And so I think multilateralism is the way forward, and doing sort of bilateral one-on-one tit for tat is probably not going to work.
Thank you. And with the remaining minutes that we have left, I'd like to turn to the audience to see if there are any questions for our superb panelists. Up here. If you'll wait for the mic.
Thank you, and congratulations, Congresswoman, on organizing this really important and productive conference. So the issue of U.S. trade remedies seems to be kind of the substantive center of concern that you highlighted and several others, I would just like to ask the panelists if you think that U.S. trade remedy law is overly biased in favor of import-sensitive industries to the detriment of consumers of those products.
This is a setup question for an economist. Long ago, in the course of the evolution of anti-dumping and countervailing duty law, both in the United States and internationally, the legal evolution of the statutes and the international obligations began to drift away from the basic economic principles of predatory pricing. That was done for understandable political economy reasons. Basically, there was a trade-off. You had to ensure political support for ongoing international trade liberalization and all of the tariff cuts and other reforms that we implemented in the post-war period. But businesses had to have some confidence that if they were in trouble, they could use laws without having to get international approval to block unfair trade practices. And so essentially you have to look at anti-dumping, countervail, and safeguards as part of the commitment to the overall system of trade reform that has evolved in the post-war period. It is not, it hits fair and unfair priced goods. On balance, are the consumers better off or worse off because of the laws? Undoubtedly, they're better off because of the overall liberalization that has occurred in the post-war period. If an economist could fix it, things would be a lot different. But if economists fixed a lot of things, we'd be in a lot of trouble. So so that's my, on the one hand, on the other hand, answer.
Can I add, I guess maybe from having voted in 600 or 800 some anti-dumping and countervailing duty cases, I do think it's important to note a couple of things. One is I do think the U.S. process for applying anti-dumping and countervailing duty measures is a rigorous one. Certainly at the International Trade Commission, I mean, you're sending out hundreds of questionnaires, you're collecting a tremendous amount of data, you are voting as a 6-person nonpartisan body on each and every injury determination. And I would argue voting really based on the facts of do the facts show that the domestic industry was materially injured or seriously injured in a safeguards case by reason of the imports that are dumped or subsidized. So I think having a very rigorous process is really important to indicate that this is not sort of just wholesale unregulated protectionism. The other thing that I think is really important that is a distinction in anti-dumping and countervailing duty cases is how narrowly focused the scope of the case is. Again, the case will be hot rolled sheet steel with a certain amount of alloy in a certain size, and that's the only thing that the duties will be applied to. If you now look at what's happening in the 232 area, it's basically all steel. I mean, anything that has steel in it. So I do think it's important to remember how rifle shot, how narrow the scope of these cases are, and how rigorous the examination is. I mean, if you look at the numbers over time of all of the cases that have ever been filed, less than 40, I think it's about 45% actually result in duties being imposed, meaning more than half of them are turned down at some stage along the way, either because the Commerce Department finds that no dumping has occurred or no subsidies were granted, or the International Trade Commission finds that the industry has not been injured. So within the United States, my answer is I think the laws are very fairly. Again, could they be changed? Could they be better? Could there be more reining in certain areas? Maybe yes, but we also have a Court of International Trade that rides herd over those decisions. And again, an appellate body and a WTO dispute settlement system that takes another look at whether they have been done consistent with our WTO obligations. So I don't think on balance that there's a good argument in the United States that there's somehow the process itself is not a fair and objective one.
Hi, Brett Fortnum with Inside U.S. Trade. The why question that the U.S. has been reiterating over and over and over again at the WTO seems in some ways aimed at the European Union, and there has been a constant battle between the U.S. and the EU over the appellate body block and the role of the appellate body. How can the U.S. get the EU, not necessarily on side, but at least to agree that some of these overreach issues must be addressed? It seems like that's one of the key steps before the U.S. might be willing to move forward.
I'll start and would ask everybody else to answer, because I've had a lot of conversations with the Europeans, because I think you're exactly right. And I think part of it stems from the United States' perception that the European Union monolithically believes that the appellate body should be the functional equivalent of the European Court of Justice, that it should function like a court that, quote, makes law in its rulings, and for which precedent becomes, again, effectively binding. I do not believe that that is actually the position of the European Union, but I understand that the United States, at least the USTR litigators, hear that. And they hear it often from litigators from the European Union that are effectively making some of those kinds of arguments. But I don't believe that is what the European Union or the European Commission, again, generally is of the view, which is why I think there is scope to come together when there is this kind of misperception, miscommunication. What do I think it's going to take? First of all, I think it is going to take the European Union acknowledging that these Walker principles or other reforms at the appellate body are needed to course correct. And I do believe that the European Union is prepared to say that and has started to, in fact, say that. I think I saw a resolution coming out of the European Parliament's International Trade Committee last week that clearly indicated a perception that the Walker principles are needed, necessary, important, moving in the right direction. So I think you will see the European Union, if you will, change to some degree its tone and its approach. In the past, it had largely said, we do not share the concerns of the United States, but we're willing to engage in this process because we care about the WTO appellate body. What you are now hearing the European Union say is very much, we think this kind of course correction brought about by the Walker principles is necessary. And I do think we need to make sure that the United States is hearing that the European Union is prepared to acknowledge some of the concerns of the United States and clearly is prepared to say we need this kind of a reform process to get the appellate body back on track.
Very briefly, I think Jennifer is right to distinguish between the European lawyers who are sort of in the weeds in the process and the position of European Union member states who greatly value the importance of having a rules-based system. In my conversations, not with the litigators, but with the commissioners, the importance of maintaining and strengthening the rules-based system is paramount. And so I agree with Jennifer. I think if the U.S. is willing to negotiate, then we'll have a very strong partner in with the European Union in strengthening the rules not only of the dispute settlement process, but also the trading rules that are needed to modernize the WTO.
Thank you, and we're out of time, so I just wanted to thank the panelists and my colleagues as well as the other participants for joining me today in this briefing. I think we got a really good understanding of the crisis that is at hand, as well as some potential paths forward. And as Jennifer said when she opened, there's a moment where we have this leverage now. We have the attention of our trading partners, and it's clear to me that Congress needs to engage with the administration on its approach on how it uses that leverage and what the path out of this current crisis is. So thank you all for being here.